I want to discuss right now about what's happening with euthanasia and assisted suicide around the world, why did we get here, and where we're going. But before that, I want to just give a little bit of a background on who I am. I grew up in Kitchener-Waterloo, the KW area, which I always love is a Tri-City region. I went to Cameron Heights Collegiate Institute, and for the record, they only discovered the body in the dumpster the year after I graduated. And the person was not murdered there, they only hid the body there. So it was, that said, I was a proud Golden Gale as well. I grew up in southwestern Ontario. I did my undergrad in Ottawa. I married a Brit in Israel, and now I live in Washington, D.C. So I joke around that when people complain about chain immigration, I am the problem. That said, for me, this issue on euthanasia and assisted suicide, I think, is a very personal one. I'll risk by going a little bit off script, but we were discussing this a bit earlier today, and I'll start with something that's called a drash, right? Which is literally in Hebrew, which is a talk. And usually on the Sabbath, there's usually a conversation about some word of Torah. And I'll just speak very quickly about this, and then we'll get to the main programming. Because I think it's very relevant to our discussion, which is when we're talking about ethical issues, right? One of the first of the ethical conundrums, right, that's in the Bible is on the Kedah, right, the binding of Isaac. And I'm sure as all well-meaning and knowledgeable believers, right, you know the story, right, which is the story of Abraham as he was promised a son, finally receives his son, and then is ordered by God to sacrifice him. And in Judaism, the story of the binding of Isaac is a very integral part. And it's one of those tensions, right, of how did Abraham know that the voice that was calling him to sacrifice his son was the voice of God? And there's a midrash, which is a sort of rabbinical exegesis, and we don't really have to go into too much, but I'll just read it out loud, because I think it gets to the very core of what we're discussing here today. And in this midrash, there's, and again, without going into too much about Jewish theology, midrash in itself is not necessarily theologically concrete, but it's one of more of a discussion and a debate. And there's a midrash that says, as Abraham and Isaac were walking, Satan appeared to Abraham and said to him, "Old man," as they're walking up to do the binding of Isaac, said to him, "Old man, are you out of your mind? You're going to slaughter the son God gave you at the age of 100? It was I who deceived you, and I said to you, take now your son." I think part of this discussion and why Abraham is so integral to the Abrahamic faiths, right, was the fact that Abraham understood the voice of God when it called out to him. Martin Buber takes this story and he applies it to the question of ethics in total. Because being able to understand what is a divine commandment, right? What is the voice of God and what is the voice of evil is the challenge of our modern day age. And Martin Buber takes this example and he says, and again, I promise you this is the only quoting that I'm going to be doing today, but Martin Buber takes this and he asks, and he says, "What therefore the suspension of the ethical is concerned, the question which takes precedence over every other is, are you really addressed by the absolute or one of his apes?" Right? The blessing and the leadership that Abraham did was he was able to recognize what was the divine calling, what was the voice of the absolute, and what was the voice of the other side. And Martin Buber goes on and he says, "Everywhere over the whole surface of the human world, in the east and in the west, from the left and from the right, They pierce unhindered through the level of the ethical and demand of you the sacrifice. In the realm of Moloch, honest men lie and compassionate men torture. And they really and truly believe that brother murder will prepare the way for brotherhood. There appears to be no escape from the most evil of all idolatry. For me personally, and again, you don't have to be an expert in the Bible to know that what I call the Hebrew Bible, what you call the Old Testament, idolatry plays a certain part. Most of the Bible is concerned with the question of idolatry. And specifically, the fact that the Israelites, left unsupervised for a couple of minutes, immediately start practicing idolatry, is one of the more concerning parts of the Bible. But I think it's essential for us, right? The question of idolatry, the question of using the words of compassion and dignity, that is the challenge of the modern day age. And I think that when we're talking about this topic, right, when we're listening to what is happening in the world, right, I don't think it's a coincidence that the debates that are happening today are debates over the meaning of dignity and human dignity, right? For the Romans, dignitas meant something akin to your standing in society. Dignitas meant your ethical worth. It meant your ability to command respect. Dignitas for every Roman citizen, and as much as Roman citizenry were heavily circumscribed, and in a way that was quite explicitly racial, ethical, or ethnic, it was sexist, right? But for this, if you were the lucky few who was land owning and who was a citizen of Rome, dignitas meant your ability to convey your ethical worth to your citizenry. For us moderns, Dignitas is the name of an assisted suicide clinic that's known for their scandals. The way that dignity, right, one of the words that comes from the Latin of dignitas, right, the way that for most Canadians, when they hear the word dignity, it is usually followed as dignity in dying. And for me personally, this is the reason why I'm so passionate about this topic and why I think it is the defining topic of our day and age. If we could describe the debate over abortion, for instance, or IVF, or stem cell research, the way that the orthodox debate was a debate about convincing to our fellow citizens what is a life and what isn't a life, right? It was a debate about saying that a human being who looks small, right, a human being who is not quite microscopic, and you can see with your naked eye, but looks different than you and me, is still a human being. The debate with euthanasia is not about that. No one is denying that someone with chronic disabilities, someone who's suffering from chronic pain, someone with an illness, someone who is of advanced age, that person is not a human being. What we're dealing with is the question of the oldest of idolatries, right? The oldest of idols, which is that the human being deserves to die on the basis of compassion. And that this is the oldest question that we have. So with that sort of segue, let me go on and describe a little bit about what's happening in the rest of the world and why Canada matters, and more specifically, why Ontario matters. As you know, over the last couple of weeks, there has been a series of setbacks in this fight over the real meaning of dignitas, right? In the UK, as you might be aware, there was the final vote in the House of Commons, and it's now going to the House of Lords, that passed one of the most dangerous assisted suicide bills that we have. And it passed the House of Commons in a third vote by barely 22 votes. By 20 votes, excuse me. 22 of those votes were by Conservative and Reform MPs, right? So if the members of Parliament in the UK who identified as Conservative did not vote for this bill would have died in the House of Commons. But they did vote, and now it is set to go in the House of Lords. In the United States, despite no assisted suicide bill, no new assisted suicide states from 2020. Just this year, the 11th state legalized assisted suicide in the state of Delaware. This was the same state whose governor just last year vetoed that same bill. But there was a new governor and there was a new legislature, and they voted for it. Also last Monday, the state of New York, after decades of fighting against assisted suicide, just voted for assisted suicide in the Assembly and in the Senate. The governor still needs to sign it into law, so there is a chance that the governor will veto, but this chance, to be frank, is very small. At the same time, there have been some positive developments. I was talking about this a little bit earlier. The American Medical Association, for the 7th time in a row, has continued to support its statement from 1994 that codifies its opposition to assisted suicide as declaring it unethical for a physician to end the life of their patient through assisted suicide. This should not be discounted. If anything, it is a little bit on the nose that the American Medical Association voted on it once again on Monday, on the same day as the New York State Senate voted in favor of assisted suicide. But this is a voice of reason in an otherwise very dark world, for lack of a better term. This resolution by the American Medical Association, they frequently vote on it. The last time this was voted on was just 2 years ago in 2023. But there was an overwhelming majority of delegates who continued to reinforce this statement. Why this is happening, I think, so actually, before going this, let me also describe a little bit about sort of my work around Ontario, and why I think we need to understand this issue a little bit better. Which is, as I think we're on the same page here, right, that we oppose euthanasia and assisted suicide, not just because it is for those who are chronically ill and for those who are not terminally ill, but rather that we oppose it in toto, right? We oppose it on the basis that ending the life of someone on any condition, any origin, any illness is wrong, both morally, ethically, and yet it is codified by Canada's Supreme Court in a unanimous decision ever since Carter v. Canada in 2015. In Ontario, I published an article in the New Atlantis about some of the cases of wrongdoing according to the Chief Coroner of Ontario. Of all the jurisdictions in Canada, there is only one jurisdiction that has wide latitudes for review of euthanasia or assisted suicide. In fact, none of the states in the US that have passed assisted suicide have any form of review process. In Australia, there are some states that have a review process, but it is very limited. In British Columbia, there's a review board, which, however, their minutes are not publicly available. In Saskatchewan, there's also a review board, but they have never met. In Quebec, there is, well, to be fair, that is an easier way of doing work, is if you never have to meet. And in fact, there are many committees that I'm part of that I wish that we never met. But in Quebec, there is an independent commission. They actually do review some of the made applications and medical paperwork, but they are limited in being able to request evidence, and they're limited in their research. And even still, I'll just mention it because this is a fact that when I talk to Americans, they just absolutely do not understand, they cannot comprehend, which is that if you go on Quebec's annual reporting by the Commission sur les soins de la fin de vie, right, so the End of Life Commission of Quebec, if you go on their annual report and you look at the underlying illness section of the report, right, and again, the top numbers don't exactly surprise us. as much as they continue to astonish with the dramatic rapidness of how Canada became the world's largest euthanasia program, from starting out at 0 just a decade ago. And if you look at that report, right, so the top one is cancer, right, then there's, you go for the report and you read about ALS, you read about neurological conditions, and a couple years ago, Quebec came out with a new form of illness. A form of illness that has never been described in any medical journal, has never been described in law, and yet it is part of this annual report. And this illness is defined as no illness or disability that would qualify under Quebec's law on MAID. Now, granted, this is in French, so I did go to French immersion, but maybe my French wasn't as advanced, and maybe all those years in studying Quebecois literature were not as well versed as they otherwise could have been. But this is really unbelievable, right? Here you have an independent commission talking about how the underlying illness was no illness that should have qualified. You would think that this would be a scandal. You would think that this would be an issue, right? For the police, maybe, for at least the Quebec Medical College. And even though the independent commission, they send all of their reports to the Quebec Medical College, the Quebec Medical College has not investigated any of them. Instead, the only cases with MAID that I've been able to find where the Quebec Medical College has actually investigated was when a Quebecois physician testified at the House of Commons in Ottawa. And because he warned, and he said that based off of his research, that he saw patients with dementia who are being coerced into MAID because there was not an adequate level of medical supports, right? Because he warned MPs who did not listen, right? The majority of MPs did not listen, though it should be said that if you do read that committee's report, that there is a minority section by all the Conservative MPs on that committee who criticized Canada's MAID program, at least for cases of mental illness and for lack of standards, which again is not nothing, though I think we can all wish that it would have been a more strongly voiced. But because this physician testified to this committee, his voice was scrutinized. And the Quebec Medical College actually launched an investigation into the core of what freedom of speech is, right? The core ideal in our system of what freedom of speech is in Ottawa, right? Is in the Parliament of Canada, where people have parliamentary immunity to discuss these issues. Ultimately, the Quebec Medical College, after investigation, discovered that his testimony in Parliament was actually in Parliament, and therefore they could not investigate further, right? But they still forced him to lawyer up, and they dragged it through the review process for a year. And this is also the same Quebec Medical College, as also you might be aware of, that they lobbied Parliament to expand MAID to mature minors, and they tried to expand MAID to infanticide, right? Or, sorry, what was the term that was used in the earlier presentation? Afterbirth abortion, right? Well, postnatal abortion is a whole field in medical ethics now. So this is really surprising, but as you can gather, that the independent commission, they do not have any powers in and of themselves to investigate this. The only jurisdiction in Canada that has a wide latitude for review would be Ontario. It is because the chief coroner of Ontario is, according to both the federal government and the provincial government, responsible for oversight of MAID. In no other jurisdiction does the chief coroner's office play an active role, even though they do have a statutory role in some provinces, but they don't play an active role in oversight of MAID. It is only in Ontario that the chief coroner is capable, able, and effectively provides some level of oversight. Well, what is it that the chief coroner of Ontario has found? And this is the issue that we're facing here in Ontario, which is that the chief coroner of Ontario, for the first couple of years after MAID was legalized, was pretty vocal about the risks and danger. In fact, in the first 100 MAID deaths, there were already deaths from things like anorexia, which I've interviewed eating disorder specialists. None of them knew that anorexia in Canada was an underlying illness that would qualify for MAID. Okay? None of them knew about it. And in fact, a lot of the discussion was about what the eating disorder community is going to do once MAID is expanded to mental illnesses alone, which now has been pushed back to 2027. Right? They didn't know that it was already happening. Okay? And in the first 100 MAID deaths, in this academic paper that the Chief Coroner of Ontario published, he also described how MAID providers were not following the law, right? Already from the first 100 MAID cases, and they weren't following the law because they weren't reporting and they weren't sending in the documentation that it was necessary for them to send, right? They weren't, even when his office reached out to those same MAID providers asking them, hey, why haven't you submitted these paperwork? They still did not send that paperwork, right? So this is, and the situation gets worse because MAID providers also weren't following. At the time, when Canada's first MAID program, one of the safeguards that existed was that there was a minimum, effectively a waiting period. It was called an assessment period. With the logic being, as the Supreme Court of Canada explicitly said, that, hey, it might be a good idea to make sure that someone's request for suicide is at least stationary, right? That that this is not an intermittent request for suicide in desperation, but instead it's a stable request for suicide, right? So the idea being, if you have an assessment period, you would be able to know. And even though the assessment period was very short, right, when Canada started, originally it was 15 days. That was the proposal. It eventually into law was 10 days, and now it is 0 days, right? Zero days. Unless, there's an exception, which is if you have a non-terminal illness or disability, then it's a 90-day assessment period, okay? But even then, as the Chief Coroner himself says, not all MAID providers follow the law, right? Which is that they do not count 90 days as days. They have unorthodox measurements of time periods, which it should be said, right? The other part that's very crucial, and apologies, I should have said this earlier, is that the law in MAID, the law in MAID, right, that's undergirding MAID is not the same laws that we have undergirding abortion, right? With abortion, it is an exception in the criminal code of what is a human life and when human life is to be protected, right? With MAID, it is codified in the criminal law with specific safeguards. If those safeguards are not being followed, right? If paperwork is not being done, if provincial guidelines are not followed, if a patient, if a person is, who requests MAID is doing it under, because of external causes, right? External factors, right? If it is not a natural, if the death is not naturally, if the natural death is not reasonably foreseeable within the context and those specific safeguards followed, right? If it is not voluntary, right? If the number of days that are required as part of the assessment period are not being followed, that is a criminal code violation, right? All of this is undergirded by the fact that MAID in Canada should be amongst the strictest of any laws that have legalized assisted suicide or euthanasia in the world. And yet it is not being followed, right? So the Chief Coroner's Office was very vocal in the first couple of years about this issue. He went so far as to send out a letter to every single healthcare physician in Ontario about the fact that his case reviews have found repeated violations of the criminal code. Okay, those were his words, right? Violations of the criminal code. In ordinary language, that is called breaking the law, which is not something that we want physicians to be doing, I'm presuming, of course. And after 2017, 2018, that's when the Chief Coroner's Office, that was the last public statement that the Chief Coroner's Office did on this topic. My report that came out in the New Atlantis showed that even though he no longer was publicly warning maid providers over the repeated violations, those cases continued and got worse. Right? So that's where, as Jackie earlier mentioned, about the 428 violations. There are varying degrees of violations, but all of them are violations that are governed by the criminal code in Canada. Right? And this is the review agency, as delegated by the federal government and by provincial governments, by Ontario, as recognized by the federal government, which, again, the federal government is clear. The Health Canada is clear that it does not do any oversight of MAID. Oversight of MAID, according to Health Canada, is done by other agencies. And they list the Chief Coroner's Office of Ontario as the agency in Ontario that does oversight. Right? So the situation is pretty dire. The Chief Coroner's Office, there was a presentation that the Chief Coroner did with nurse practitioners, registered nurse practitioners, if we want to be completely accurate. He discusses a blatant, that's his word, a blatant violation of the criminal law, of MAID laws. And this scenario, this situation, which happened, again, the only reason we even know this is because the chief coroner discussed it with the nurse practitioners of Ontario. And the only way that and that's what tipped me off to be able to search for like the nurse practice, that's what led me to search the Ontario College of Physicians and to find that case study. But that was not publicized. I don't know why it wasn't publicized. You would think that it's important for the Ontario public to know when there's a blatant violation. And this was, and in this instance, it was pretty much the most egregious form of violation of a physician's duty, because it was a palliative care physician who did not know anything about MAID, did not know anything about what was the medication, so-called medication, that was used for MAID, did not know any of the requirements or eligibility criteria, did not know any of the safeguards, did not know that they needed to report it, the MAID death, to the coroner's office. And the physician just used an ad hoc killing did an ad hoc killing solution where she just went to the pharmacist, which by the way, the pharmacist, which she didn't report to Ontario either, even though that's another legal requirement, and she just tried killing her patient, who took many, many hours to die. To make matters even worse, because the patient was taking so many hours to die, presumably suffering, the physician left the patient to get more medication to kill that patient, right? So this is one of this is the most egregious form of breaking the laws with MAID, right? Here's a physician who had no idea what the legal requirements were for MAID, and to make matters even worse, the only reprimand that this physician had was that her palliative work needed to have supervision, right? So she could continue being a palliative care physician, and only was curtailed from doing any MAID assessments. Right? So you break the criminal law, and your punishment is, well, you can continue being a physician. Right? No wonder the Chief Coroner's Office described it as a blatant violation. And yet, it wasn't the only one. Again, we don't know the exact, that's the only case that we know exact details, because it was the only case that Ontario's College of Physicians actually reported, because they put that prohibition on her service, right, on her medical career. That's the only reason that that's public, right? All of the other instances of MAID violations never went that far. And yet, this was the first time anywhere in the United States, in Australia, in Ontario, in Netherlands and Belgium, that a physician in a legal euthanasia program received some form of reprimand, right, by the medical colleges in a legalized system. So it is not insignificant, and the public should be aware of how many similar cases there are, right? How many times MAID paperwork is not being filed, right? How many times signatures and witnesses are not properly being attested, How many times due diligence is not being done around MAID, right? This is about the death of a person, right? This is what is an exception in the criminal code for culpable homicide, right? This is according to the Criminal Code of Canada. This is an exception for assisted suicide, though almost every case in Canada is through euthanasia, through lethal injection. And the problem is only getting worse. So in 2024, at CAMAP, the Canadian Association of MAID Assessors and Providers annual convention, the Chief Coroner of Ontario once again was essentially begging MAID providers to follow the criminal law in Ontario, at the very least, right, about MAID. Right? So these are situations where MAID is an offense. At the same time, we shouldn't be so shocked about this. In Quebec, Quebec expanded MAID already to cases where there's dementia, right, and to have advanced requests for MAID. This is in violation of the criminal code. The RCMP said that despite this, they're not going to follow the law. Right? I think that this should enormously alarm us, right? When the police are unilaterally saying that they're not going to follow the criminal code, right? So there was a question of moral arbitrariness. I don't know what's more morally arbitrary than the police saying that we're not going to follow a criminal law that was amended by the Parliament of Canada in response to a unanimous Supreme Court decision, right? It is, in effect, a form of tyranny. Now, beyond this, I should also mention that there are huge questions over, even though, so let me explain a little bit what an advanced directive is, right? An advanced directive is, most people should have a form of advanced directive, which is just specifying what medical procedures you would like done at a certain point in your illness when you are no longer able to be mentally competent enough to direct your medical care. Advanced directives for MAID are saying that when I lose capacity, I want to die through MAID. Now the issue is that capacity, as we should know, especially if you've dealt with any family member who has some form of neurological illness, capacity comes and goes, right? Capacity isn't an on-off switch, right? It's ebbing, it's flowing. Family members, as you know, sometimes have better days, sometimes they have worse days, right? Sometimes they're mentally competent, sometimes they're not. And beyond that, the question of competence is that the oldest form of, again, you can just read John Locke, right? The idea that one person cannot consent to one's own murder is a foundational value in our system of law and ethics. And yet that has been completely ramshotted through. But even still, let us think about the entire point of MAID is that it's an elective procedure, right? According to the Supreme Court's own rationale, it is that you are choosing to die for MAID as a competent individual, right? And the person who is dying is not competent, right? This is kind of similar to the whole debate over VSED, right? Voluntary cessation of eating and drinking, and how quickly voluntary cessation of eating and drinking has now been applied to withdrawing hydration and nutrition, right? Completely forgetting the first letter, which is an amazing fact. But with MAID, right, with what is happening in Quebec, is that they're now allowing advanced directives. Now, the question we should be asking is why? Because Canada's criminal code was amended once again with MAID in 2021 through Bill C7. Besides removing different safeguards like assessment periods, lowering and also expanding MAID to those who do not even have a terminal illness or disability. It was also, one of the other exceptions was to add a clause saying that people can sign waivers where they waive their rights for final consent before they die through MAID. So you would think, well, wasn't this a form of advanced directive? And the answer is yes, it is a form of advanced directive. I've had many, many debates. That is effectively what they did. And in fact, health is the cabinet ministers responsible for implementing this in the Ministry of Justice and in Health Canada, as I uncovered through filing a freedom of information request, they knew that it was a form of advance directive, right? That they knew it. And their talking points were overnight went from, should we debate advance directives, to, well, this is now a waiver of final consent. Now, so why does Quebec need to then go even a step further beyond that, right? If we already have a waiver of final consent. And the reason being is because what the legislation in the criminal code says is that this waiver is only valid if the person who is dying through MAID is not resisting for either physical or verbal acts, right? That's what's written in our MAID legislation. That's what's codified in our criminal law, right? And think about the level of barbarity. Again, I'm completely plagiarizing the earlier presentation, but I like that word. But the level of violence, right? That here are MPs discussing amongst themselves. They weren't forced to do this, right? It was a court case in Quebec, the Truchon decision, which Canada's government decided not to appeal for whatever reason, even though virtually every single disability organization in Canada was begging the government to at least appeal that decision. They weren't forced to do a waiver of final consent. There was no, that wasn't even part of that original legislation, or the original court case, excuse me. Just as they weren't forced to expand MAID for mental illnesses. And in fact, the way that it was added in was as a last-minute amendment in the Senate for expanding MAID for mental illness. So the House of Commons didn't even really have a chance to debate this because it was already decided in the Senate. As you know, our Senate is not democratically elected, and it is a little bit bizarre for the Senate to spring on the House of Commons and then to get the government to ramshod this amendment. So why is it then that Quebec needs to go a step further? Well, I wrote in a cover story for National Review that MAID physicians, CAMAP, openly discussed and laughed about using this waiver of final consent, because the wording of that criminal law is if you show physical or verbal signs of resistance for the MAID death, right? So what happens if you first sedate the patient? And a physician, and several physicians were laughing about using hydromorphone to sedate a patient, and even though that patient could then resist that sedation, they weren't resisting the MAID death, right? Because they were already sedated. And that is, I think that is the reason why you have these jurisdictions pushing even beyond what is already a very wide latitude, right? That we already effectively have advanced directives. So let me also go a little bit more about, how am I doing for time?
Okay.
Is it?
Yeah.
Okay.
Yeah, we're looking at about 20 minutes.
Okay. I'll try to finish a little bit quicker so we have questions, but let me just go over a little bit more about why this matters, right? And what it matters is that, unlike with abortion, right, the court legislated. With abortion, the Supreme Court of Canada did not enshrine a positive right to abortion, right? It only said that you cannot have a blanket ban on abortion, right? With MAID, the Supreme Court of Canada did enshrine a positive right to euthanasia and assisted suicide, right? That's how we have, and at the same time, the Supreme Court of Canada did not enshrine any right for healthcare, right? So that's how we have that the median waiting period, right, between requesting MAID and dying for MAID in Canada in 2023 was only 13 days, right? That includes from requesting MAID, applying for MAID, sending in the written paperwork, getting two physicians to do assessments for you, scheduling your final end of life, your funeral, and then scheduling the MAID appointment, getting that MAID appointment, and then dying for MAID. That was only 13 days. The previous year, it was 11 days. And that's median, right? So 50% less, 50% more than that. Getting a CT scan, which is not an elective procedure, right? In Canada, on average, according to the Canadian Institute of Health Information, was around 40 days, right? And this is MAID should be the definition of an elective medical treatment, right? And yet that is being speed-run because there's no positive right for healthcare in Canada, but there is a positive right for a medically assisted death, so to speak. And yet, if you read the Carter decision, you quickly realize that that the underlying logic, right, what the Supreme Court expected would happen with MAID in Canada, is no longer happening. It is a case of buyer's remorse. And in fact, even in the British Columbia Civil Liberties Association, which led the MAID, which led the entire MAID, the court case that became Carter v. Canada, they already are having buyer's remorse over MAID, right? There was a news story that broke out last year. Now, I did lie when I said that was the only thing I was going to quote, so forgive me, but I'll just read briefly in Carter, because I think this is where the opportunity lies in opposing euthanasia on demand, is when the Supreme Court of Canada said, to be accurate and reliable, clinicians who perform MAID assessments, they use a different term, but who perform MAID assessments would have to be aware of the risks of coercion and undue influence, of the possibilities of subtle influence, and et cetera, and I'll skip a bit, regarding the qualities of the lives of persons with disabilities and advanced age. Okay? They assumed, and speaking of the earlier idolatry, right, they twisted within the Charter of Rights and Freedoms the right to life as the right to die. And the underlying logic was on the basis that if people who want to commit suicide because of their neurological illness or because of their physical illness or disability would be unable to commit suicide when they want to, which is when they're later on, mentally competent but physically unable to commit suicide. Therefore, we need to legalize assisted suicide and euthanasia, so people in that state of mind would be able to have that as a fallback option, and therefore there would be a right to life for those individuals because they can live further on, and maybe they'll realize that they can live with their illness when they otherwise would have committed suicide, right? That was the underlying logic, okay? The reality on the ground is that that hasn't happened, right? We have seen a 13-fold increase in the number of MAID deaths, right? From 1,000 deaths in the first year to now we're 13,000. We have seen, at the same time, the suicide rates have pretty much remained stable. So we have seen one of the fastest growing rates of MAID, or we have seen the fastest rate of growth in euthanasia anywhere. And beyond that, there were entire discussions in the Carter decision that this would not disproportionately impact vulnerable groups. In fact, the promise was that if the Supreme Court of Canada thought that there was going to be a disproportionate risk to vulnerable groups, then then euthanasia should not be legal anywhere in Canada, right? That was the explicit wording. Well, let's look at the data, right? And from 2019 to 2023, and this is going to be a new report that's coming out in Cardiff soon, Bezrat Hashem, is that 42% of all MAID deaths are because of disabilities, right? 42% are people with disabilities, okay? I don't know how you can say that that is not a disproportionate impact on people with disabilities. A majority of all MAID deaths are either with people with disabilities or people of advanced age. There has been over 1,000 cases of track 2, 1,017 cases where people only on the basis of disabilities have qualified and died from euthanasia. And the part of the Carter decision, which is describing how physicians need to be aware of the possibilities of coercion, well, here's the reality. In 1/5 of all MAID deaths, the MAID physicians do not know if the person who they are killing, effectively, and I think I can use that word here, they do not know whether that person requires disability services or not. Right? Think about what that means. How can you know whether someone has the possibilities of being coerced if at the same time you don't even know if they need any disability services? So let's go on. Another part of the statistic, the Supreme Court of Canada, when they were discussing about how this wasn't going to impact people with disabilities, they looked at the Netherlands in 1991, and they found that in 0.2% that only 0.2% of euthanasia deaths in Netherlands in that year were people who had a life expectancy of more than 6 months. Okay, that was what the Supreme Court of Canada said, and they found that in the Netherlands, most people who die for euthanasia were dying in a matter of hours or days, and therefore their life, it shows that people who have a longer lifespan, they would not be impacted by this. Now, of course, I think we can realize that the life of a human being the dignity of a human being does not depend on the immediacy of their deaths, and that someone who is dying in a matter of minutes or hours is still a human being with equal dignity and value as anyone else. But even putting that aside, if you look at the data today, is that in Quebec, which is the only province in Canada to record on this data, 20% of May deaths are people with a life expectancy longer than 6 months. A majority of May deaths in Quebec, and assuming that the prognosis rates in Quebec are similar to that in the rest of Canada, a majority of May deaths are people with life expectancy of over a month. Right? And why this matters is because prognosis estimates, as any physician will tell you, of natural remaining lifespan diminish with more time that passes. So you went from assuming that euthanasia was going to only apply for people who are dying imminently, to now dying over a much greater rate of time. We also see that rates of depression people who apply for MAID and die for MAID are more likely and disproportionately to have psychiatric comorbidities. They're more likely to have depression. There was a retrospective chart review in Toronto that was published a couple of years ago that showed that 39% of May deaths in this tertiary hospital were people who had some form of psychiatric illness. This is higher than in any other jurisdiction. So in Oregon, they found that one of the earlier chart reviews showed that around 1/5 or 20% of all assisted suicide deaths in Oregon were people who had depression. So we don't know the exact figures, but here you have people with psychiatric comorbidities. We also know this is worse for Track 2 cases, where there was another chart review which showed that a majority of Track 2 cases were people who had some form of depression.
Sorry.
Yeah.
Everybody may not know what track 1 is.
Oh yeah, sorry. So Track 1 is when, so MAID since 2021 has been divided into Track 1, which is when someone who has a natural death that is reasonably foreseeable. If you know what that means, that's more than what the Parliament of Canada knows. Which if you have seemingly a terminal-ish illness, that is Track 1, and you can have same-day MAID assessment and MAID provision, i.e. die through MAID. Track 2 is when your natural death is not reasonably foreseeable, which means whatever it means. So there's not even, with the whole looseness of the term natural death that is reasonably foreseeable, that can mean that you're many, many years away from dying. Right? Or you just have an illness or disability, or chronic illness or disability. But I want to end off on a note, which is just the sheer scale of May deaths, right? And the scrutiny that's provided. According to the Carter decision, one of the key data points when they were looking at whether physicians were going to be scrupulous in approving MAID only for cases where people are not depressed, where people are not being coerced, either through an unsubtle or explicit means of coercion, was that they looked at the percentage of MAID requests that are actually approved and end in an assisted suicide. So in Oregon, for every 100 May deaths, they found that 900 of those. Excuse me. Let me rephrase this. So for every 100 people who die for euthanasia or assisted suicide in Oregon, there were 900 people who requested it. For every 100 euthanasia deaths in the Netherlands, there were 200 people who requested it. In Canada, for every 100 May deaths, there are only 28 people who requested it, and did not receive it. The basics of this is that the Carter decision is not ancient history. It was just a decade ago that it was decided. And we do not need to go and invent any amendments in the criminal code. We do not need to go to Parliament to even introduce new legislation that would supersede it. But rather, we just need to be able to ask, as a starting point, let us follow the criminal law, right? Let us follow the rationale that the Supreme Court of Canada did in the Carter decision. We don't need a new Supreme Court decision. We just need to follow the basic logic and the data points that the Supreme Court of Canada did when they looked at other jurisdictions. And instead of looking at Belgium, instead of looking at the Netherlands, instead of looking at Switzerland or Oregon or Washington State, let's just look at Canada. Let us look at what the data says about Canadian-made deaths, and let us use the same consistent logic that was written just a decade ago, and let us compare, and let us see if people with disabilities and people of advanced age are being disproportionately targeted and dying for this program. Let us see if, even under their definition of the fact that a suicide is only for someone who is not imminently dying, let us use that definition, and let us ask a basic starting point, which is, are we following the criminal law in Canada with MAID? And I think the answer is a resounding no. And I think I'll end there, and if people have, do we have time for questions?
10 minutes.
10 minutes, but I'm also cognizant of the fact that I'm between you and lunch, so that is a very dangerous position to be in.
We'll do 10 and then we'll have only 40 for lunch. So I'm sure
Okay.
we'll start.
Do people have questions? Yes.
Is there any way we can find out the names of these doctors and nurse practitioners who are doing these MAID deaths?
So we know some of them when they publicize it. We know some of the worst cases because there are lawsuits. So for instance, in British Columbia, Ellen Wiebe has been through a role for British Columbia. And from my understanding is that there's 2 civil cases that were filed against her by family members of people that she allegedly killed. And these are cases where, like, one of them was like someone who was like on a psychiatric day pass, and she somehow assessed him despite the fact that he was in a psychiatric institution and allegedly prescribed and administered MAID in that time. Now, I do also want to mention that for MAID physicians have been very, in a lot of provinces, the confidentiality of MAID providers is codified in law. So and they do that, I think, because I think they realize that what is happening is wrong. But I do want to mention that I do think from the conversations I had with MAID providers is I think that it is an example of idolatry in the most basic sense, right? They really do think that they're working out of compassion and dignity, right? So the question is, how do we convince those people, as we convince the people that they're killing, ultimately, that human life is worth protecting and preserving? And I do think that in those cases, there already have been MAID providers who otherwise administer MAID for track 1, for those who are terminally ill, who are now balking at the fact that they have to administer it for track 2. So I think that is the space that we can pursue. Yes?
So you said that the RCMP wasn't willing to proceed in Quebec on these blatant misapplication of law. Can the Ontario coroner not submit
Yes.
for prosecution?
Yes. Yes. So of the 428 cases where the Chief Coroner of Ontario found that there was a lack of compliance with MAID legislation, he sent 0 cases to the police formally. Right? So it's possible that he sent it via an email, but he did not formally submit any of them to the police. Right? And this is something to the police or to, and only a handful were to the College of Physicians. Right? And in fact, one of the things from from my article that came out is that according to his rubric about which safeguards he's actually reviewing and which safeguards he's essentially he's just sending an angry email about, One of those safeguards that he wasn't going to immediately introduce to the police was a safeguard that someone has to be over 18 years old to qualify and apply for MAID. And after my report came out, then the chief coroner's office then said, okay, actually we're changing that. In that instance, we will be sending it to the police, right? So, but if you think about it, that's the type of safeguard. If the person responsible for oversight thinks that a minor, which, dying for MAID, is clearly not that big of a deal that it actually needs reporting to the police, then you can imagine how lesser safeguards, so-called lesser safeguards, would fall through the cracks.
Just wondering if he's under pressure from.
Oh, 100%. I mean, 100%. The fact is that he was warning MAID providers at their conference, of repeated violations of the criminal code. I think it is fair to ask under what pressure he is, right? And why between, from 2017 to 2024, despite the problem getting worse, not better, he stopped informing the public of the risks.
Have any of the lawsuits successfully gone through court yet, or are they still buried?
No. Actually, I should say there have been a couple cases. So there's 2 cases that I'm aware of in Nova Scotia, or I think it was Nova Scotia, in one of the Atlantic provinces, and also in Alberta with like the 28-year-old who applied for MAID despite only having diagnosed conditions of autism and ADHD. They won at the preliminary injunction phase, right? So the court said that for the time being of this court case, physicians are not allowed to euthanize that patient, but they ultimately lost at the trial stage. So the fact that you have these 2 lawsuits against Ellen Wiebe, and that they're going through civil courts, right, civil cases, and that these are by angry family members, which, by the way, Ellen Wiebe is on the record of saying that again, I'll never forget this for the rest of my life. She's on the record of saying that angry family members are our greatest risk, right? And then she laughed. So presumably that was a joke, but all of a sudden now, here you have angry family members who are going after her for medical malpractice, alleged medical malpractice, I should say, but these are the first cases. Really, it should be the police because this is a criminal code violation, and it's a criminal code violation of culpable homicide. Right, so that is, in theory, that it can be, over 10 years in prison. Yes?
One of the things that I really appreciate is how you are educating us. And I maintain that at this stage, as a pro-life movement, we're kind of almost octogenarian, and it's as if we need to we need to re-educate ourselves. To a very great extent, I do think that we need to share information in a manner that also doesn't lose touch with the past. Now, I don't mean to be critical.
No, please.
But one thing I must say, in light of the need to, educate, is that one of the things you mentioned about the Morgentaler decision. In fact, Bertha Wilson made clear that there is no constitutional right to abortion. When she referred it to Parliament, she didn't say that you cannot ban abortion, okay? As a matter of fact, if the words we were talking about earlier, after becoming a human being, were removed because they were added by John Turner, then right away every abortion would be manslaughter.
Yes.
Okay, so that's doable. It's not that it's politically popular.
Yes, no, I agree. I should have said that the contemporary ruling on a blanket ban on abortion that the Supreme Court.
Yeah. The other thing is that, you were talking about how this MAID legislation, the fundamental flaw of the Supreme Court, actually goes before that. The Supreme Court's fundamental flaw was at the very beginning, where the predicate that it was using in the judgment is that people have a right to commit suicide.
Yes.
But, we have a moral principle that you don't have a right to sin, and in fact, you did quote Locke. We don't have a right to vitiate our own lives, the right to our own lives. You don't have the right to do that. So anyway, for what it's worth, I just want to note that the reality is that MAID creates an entitlement where there is not a right. That's what it's actually doing, creating an entitlement. Okay, thanks.
Yes. No. All of that is very well worded, right? I do think we have. like, we can spend the rest of today just talking about the ways that the Carr decision went wrong, right? I'm just saying that even if we presume their assumptions, right? Even if we just assume, you know, we just take it for granted, right? The Carr decision is just still inconsistent with the way that MAID is implemented in Canada.
So legally, if none of us knows how we are going to die, obviously.
Yes.
Tomorrow I can lose my mind or
Yes.
my capability to communicate. If I tattoo do not kill me, do that give me some kind of legal protection?
I think that's a better conversation with a lawyer about this. Now, the issue is that in Ontario, this is actually a whole separate issue, but for do not resuscitate, like DNR orders, there was already a court case, not that went all the way to like an appeal, but it didn't go to the Supreme Court, where, so the law of the land right now is that physicians don't have to tell you that they put a DNR order against you, right? This is different than in other jurisdictions, but this is the case in Canada, where they do not have to tell you. So if you put a sort of an anti-DNR, from my understanding is physicians do not legally have to inform you or to follow that. So yeah, I mean, it is deeply concerning, and you know, I do think that a lot of the reasons why we've fallen the way that we've fallen in Canada is because of this sort of logic of DNR as you know, as a patrilineal, sorry, not patrilineal, but as a you know, as physicians doing better than you do about the value of your life. And I don't think it's a surprise that we are reaching the sort of nadir at the same time as physicians are allowed to just implement DNRs without even informing you or your substitute decision maker about this. And to be fair, the medical practice is it's better to inform you, but they just don't legally have to, which is insane for lack of a better term.